Ms. Kaufman, good morning. Yes, it's still morning.
May it please the Court, Nancy Kaufman for the Office of Bar Counsel. Today, I'd like to focus this argument, which arises from a reinstatement proceeding and is here before this Court on a reservation and report. I'd like to focus on the burden of proof that applies in a situation where a disbarred lawyer is petitioning for reinstatement and whether or not this petitioner did practice law during the term of his disbarment. In matter of his, this Court said at three different points in that decision that the burden of proof is heavy when an individual is petitioning for reinstatement after disbarment. Now, what heavy means has not been further defined, but also in that decision, this Court said that the record would be closely scrutinized by the Court before allowing a petition for reinstatement. So the question is whether a petitioner is entitled to reinstatement when the panel finds that the case is extremely close and that he has barely met the burden.
Well, maybe that means he's barely met the heavy burden that is imposed upon him.
Well, I don't know how that could be if it's an extremely close case.
Well, it can be close as to whether or not you've persuaded me by clear and convincing or whatever the standard is.
Right. The Court's actually never used those words, clear and convincing. It's never said anything more than heavy. So from a public perception point of view, if someone appears to have barely squeaked by whatever it was that had to be shown in order to be reinstated, is that sufficient to say to the public, as this Court wants to say, that yes, this is a person worthy of trust, that we can hold this person out as trustworthy even though he was disbarred? Now, in this case, there was very little evidence of reformation of character. There really wasn't a demonstration that anything had changed.
Why do you say that?
I say that because there were two major reasons that Mr. Ellis identified for his disbarment. One was that his firm had too many cases. He took on too much. And the second was that he relied on his family members to make decisions for him, and he didn't assert his own independence. But there was nothing in the term of his disbarment to show that any of those things had changed. For example, when he got out of jail, he wasn't sure what he was going to do. His father suggested that he should take over these over 1,000 collection cases. He felt uncomfortable doing that, but his father and others convinced him by telling him that he was ethically required by the rules of professional conduct to sue his clients to recover those expenses.
And so then, in an abundance of caution, he got opinions from leaders in the bar as to whether or not that would be an ethical violation, didn't he?
No, the point
So it was more than just the family advice that he was following.
No, the question isn't whether he was violating an ethical rule by suing former clients. The question was whether he was required, he said he believed he was actually required to bring those lawsuits. There's nothing in the rules that required him to sue his clients. Nothing. It was not a feeling, he was not testifying that he thought he might be violating a rule of professional conduct by bringing the lawsuits. He thought he was required to bring the lawsuits.
Well, do you think he was violating a rule?
By bringing the lawsuits?
Yeah.
I think he was violating a rule by bringing the lawsuits and representing his brother and having his brother representing him.
But assuming for the minute that he was bringing the lawsuits pro se, but as a disbarred lawyer, that's not a violation.
He could represent himself. There's no question that he could. It has always been from day one Bar Counsel's position that he could represent himself.
Well, rules provide that, don't they?
I beg your pardon?
Don't the rules explicitly provide that?
The statute. There's a statute.
I mean, the statute.
Yes, yes, absolutely. You have absolute right.
It's not just Bar Counsel's position. It's.
Oh no, I'm just saying in the dispute between Bar Counsel and Mr. Angelini, who was representing all of the Ellises, the father and the two sons, we never disagreed that either one of them could sue on his own behalf. James Ellis Jr. can sue on his behalf, Nicholas Ellis could sue on his behalf. We never disagreed with that.
Yep.
The disagreement was over whether either one of them could represent the partnership or the other brother. That was the only disagreement.
Are you and maybe I just didn't hear you, are you saying, in response to Justice Ireland, when he said he thought he was required to, are you saying that that goes to his moral qualifications or his legal, his sort of competence to practice law? Which one are you putting that to?
Well, we started down this road by asking what had changed.
Right?
And I was describing how he attributed each of his, I was beginning to describe how he attributed each of the decisions that he made to family members. Not that I decided I was going to do this, not that I decided this was the best thing for me to do, while I'm trying to get my reputation back, which was what his major concern was when he got out of jail. So that was the first thing that he did was, well, his father suggested this. And then he took really very little interest, it appears, in what happened to the money that was collected from these 1,800 collections cases. And he wasn't sure where to deposit that money, so then he went to his sister, who is not a lawyer, and she said, well, this money should be go into our father's IOLTA account. Again, he took no responsibility for that. That was his sister's idea. He went along with it. That was incorrect. That was improper. Exactly what decisions he made on his own, how he asserted himself against whatever his family thought was right or not right, there's nothing of that in the record. So,
Do we know what the father's cut was of these cases? I gather the father got some cut.
well, it's very difficult to determine exactly whether the father got any cut of the cases. We do have in the record, we were able to get some bank records that we subpoenaed, and we have schedules. We show money going from the father's IOLTA account into another IOLTA account of the father's.
I thought the father assigned all these collection cases to the sons.
Yes, well, there are a number of different versions of the assignments, but under one version, yes, the father did assign all the collection cases to the son. In the record, you'll see representations made by James Ellis Jr. that there were a number of assignments. First, the sons assigned all of the claims to the father, then the father assigned them back to the son. In the petition for reinstatement, the claim was that the father made an assignment to the sons sometime in 2000 or 2001 and assigned the claims jointly and severally, and so that each son owned them jointly and severally with each other. And then at the hearing on the petition for reinstatement, it was testified to by Mr. Ellis that there was some kind of consideration paid, but mainly in manual labor performed by the petitioner for his father. In return for these assignments, although why there had to be an assignment in the first place was never really answered, because in fact each individual, the father's firm and the two sons, owned these claims. And when the father's firm became a partner with Ellis and Ellis, and this exhibit is also in the record, all of these collections cases that had accumulated up to the time of the temporary suspension, it specifically provided that they belonged to the sons and not to the partnership at all. They would be the responsibility of the two sons, both liability and the assets. So again, the record shows quite a number of conflicting versions of these assignments and why they even had to take place.
Do we have any prior cases in which we have reinstated somebody after a conviction and imposed limitations on who they can practice with and the nature of cases they can accept?
Let's see, after a disbarment.
After disbarment based on a prior conviction?
Based on a conviction. I don't want to answer that question because generally there's a case for every proposition. But I can't think of a case where these types of restrictions were recommended. That's not to say that lawyers haven't been restricted on the types of cases they can take. I'm thinking there was a lawyer, I think in Jackman, he wasn't disbarred, but he was not allowed to take on any personal injury cases. One of the conditions of his suspension was that if and when he did get reinstated, he would only be able to handle, I think, criminal cases. So there has been that kind of restriction, but to say that you cannot associate with these individuals, you cannot do any work with these individuals, these types of restrictions I can't think of a precedent for. The board cited halal as precedent for restrictions, but if you look at the restrictions that were imposed in halal, which Bar Council, by the way, acceded to or suggested, they go to his psychological condition, that he had to maintain a certain, get therapy and maintain treatment as long as it was recommended. Nothing like the restrictions here, which we also suggest show how concerned the panel was with the fitness of this Mr. Ellis for reinstatement. So when we look at this, evidence of reformation, as this court said in Matter of Weights, is a state of mind that has to be demonstrated by conduct. And what we say is if you look at the record in this case, you're not going to see any conduct during the time of the disbarment that shows that Mr. Ellis has achieved any kind of independence from the influence of his family members and from relying on others to make these important decisions for him, even decisions that affect the professional responsibility of his father and that he should be aware of too. Now, we'd also like to address the question whether the petitioner practiced law during the time of his disbarment. And first I want to say that the case that Gorovitz versus the Planning Board of Nantucket that seemed to have a great deal of sway with the panel really has no application here. And that is because the petitioner never testified in these proceedings that he thought he was able, under that case, to represent the partnership or his brother. He testified that he knew from the time he was out of prison that he was not allowed to represent his brother and he was not allowed to represent the partnership. So he did not have to consult with Mr. Angelini about that. He understood that, according to his own testimony. The other point that I would like to make is that when we filed the petition to hold James Ellis Jr. in contempt, which we did in the spring of 2008, and it was in the spring of 2008 that James Ellis Jr. was appearing in the Demers case, not only on the claim for expenses, but also to defend against a malpractice claim against the firm. When we filed that petition for contempt, I think it's fair to say that the major reason that that petition for contempt failed or was not granted was because James Jr. said that he had an assignment from his brother to handle that case, and that was their practice, that each of them would assign to each other. After the father assigned all of these collections cases to the brothers, they would then assign cases to each other so that one person would own 100% of the claim and would not have any, there would be no issue that brother was representing anybody but himself. In the reinstatement proceeding, however, Nicholas Ellis testified that there were no assignments, at least not before judgment. And therefore, the whole crux of the decision that exonerated James Jr. does not exist in this case, and the panel found that there were no assignments. So if you look at what happened in the LaPlante case, if you look at the transcript of that proceeding, if you look at the testimony of Mr. Rummo, and you look at the documents, the pleadings that were filed, and the testimony of Mr. Ellis, who said that they would both go to court on these cases, and yes, one brother would handle the hearing. Those judgments were entered for both of them, and there were no assignments. Finally, I just want to say, address one claim in the petitioner's brief, which is that Bar Counsel was fully apprised of everything that was going on in these collection cases and knew what was happening and did not take any action. In fact, if you look at Exhibit 3, which is the argument on the petition for contempt, Bar Counsel made very clear that we had not been able to get a list of the cases. We had not been able to obtain, in fact, we did not get a list of the cases that were being brought until the petition for reinstatement was filed, and we were not apprised that the brothers were going in and representing each other in these cases. And as you know, the brothers actually denied that they were doing that. So we think that the record here simply does not support reinstatement in this case and would ask that reinstatement be denied. Thank you.
Thank you, Ms. Kaufman. Mr. Carney?
Madam Chief Justice, other justices of the court, good morning. My name is Jay Carney, and I'm pleased to represent the appellee, Nicholas Ellis. It's a little unusual for me to be going second before this court, but I'm enjoying it.
Mr. Carney, let me ask you this. You are not challenging the conditions, am I correct?
We embrace the conditions,
Okay.
Your Honor. It's my client's view that even though all of those conditions were things that he would willingly do, that he had told the hearing panel that he would be willing to do. Indeed, in his application for reinstatement, he explicitly said, I am not going to be practicing law with my father. I'm going to practice different areas of law. I'm going to be practicing in a way that is totally different from how his father and older brother's law firm was. The hearing panel put these conditions on. We embraced them.
What if some additional conditions were added? What would you think of additional conditions that limited him, restricted him from the type of financial transactions that might have caused or could cause problems, like the Social Security disability and the insurers and workers' comp claims?
For workers' comp, he's already prohibited from, correct?
Yes, Your Honor. Workers' comp is
Yeah,
covered.
right, okay, the others.
Social Security, I think that's kind of a different practice because of where it's litigated, and he does have significant experience in Social Security, and it's basically representing people who feel they're entitled to get federal funds, often because of a disability.
What do you say, Mr. Carney, to the argument that Bar Counsel makes that in this period of time from the conviction to the present, that the record reflects somebody who is still not making decisions on his own, that he, as she would put it, you know, he says, I did this because my father suggested it, or in other words, the family influence is there, A, and B, it doesn't show a whole lot of independent judgment.
One has to remember the time period that we're talking about. Nicholas Ellis, married with 3 young children, ages 5 through 7, I believe, had now just been released from 3 months in the House of Correction. He needed to find employment. He took a teacher's certification program, was certified as a teacher, but this conviction prevented him from getting a job as a teacher. He looked around for other employment. Here's a person whose father says, well, I will assign these matters to you to collect the costs that the law firm advanced, that in fact Nicholas Ellis and his brother advanced, because you're entitled to recoup them. And in return, I want you to build a stone wall on my property. Nicholas Ellis was desperate to find a way to support his family, but he did not take what his father suggested. He did not take the urgings of his brother. Nicholas Ellis said, I want to make sure that if I do this, that it's okay. So at his request, Attorney Michael Angelini was consulted about how to do this. In the old days, to be honest, the father and the brother would just steamroll Nicholas Ellis. If he raised a question, his father, who treated him like a child, and his brother, who just overrode him, would have said, there's no need to call Michael Angelini. Just do it. But the petitioner said, no, I want to talk to Michael Angelini. And then he got an opinion from him. The record also states, if I may add one other point, excuse me, that it was the petitioner who asked Attorney Angelini to notify bar counsel of what he wanted to do. So here's a person, instead of following exactly what his father and brother said, is doing something different and saying, please, I want bar counsel to know. Attorney Angelini explained to bar counsel what the process would be. Bar counsel said, you can't bring the cases in a caption that is Ellis and Ellis, even though that's from whom the assignment was received. You must bring it in your name and your brother's name.
But weren't there cases filed on behalf of Ellis and Ellis? I thought that was in the record.
Yes, Your Honor. At the time my client was incarcerated, his father had filed numerous district court and small claims actions.
Did he ever move to amend the complaint and say, no, this is not Ellis against Ellis, Ellis and Ellis, this is just me per se?
Well, the majority of these cases were small claims actions.
Yeah.
And watching how small claims cases are handled, they're really kind of fascinating in the district court. They're handled by a clerk magistrate. They're handled with great informality. The clerk magistrate attempts to see if the parties can be resolved. You're looking for what? $500? You're willing to offer what? $300? And they broker it, and it's very informal. If you brought a motion before a clerk magistrate to amend the pleading to change the title from Ellis and Ellis to James Ellis and Nicholas Ellis, the clerk wouldn't know what to do. He would just take it and say, please, I'll speak to you at the hearing, and on that day when they have 30 people lined up for small claims.
No, I understand that, but I mean, he still had the opportunity to amend the pleadings.
He did, Your Honor. But for those cases that were already in suit, he went forward. For the ones he brought, he did explicitly what bar counsel suggested and put them in the two names.
Now, Keenan and Hiss and Prager all speak about the heavy burden to show that he's become, quote, a person proper to be held out by the court to the public as trustworthy. What do these conditions say about whether or not he's being held out as a person trustworthy? Trustworthy as long as he doesn't practice in the area of workers' comp and personal injury? Trustworthy as long as he doesn't practice with his father or his sister?
I don't view it the same way, Your Honor. I view the hearing panel and the board as putting in conditions which the petitioner has already said he was going to follow in order to ensure that there will be no question about it. That's why he did not dispute them. That's why he has embraced them. And it will make no difference in how he will practice law. I believe that when the court, in a case such as this, imposes conditions, that they are designed in part to assist the lawyer in the transition back to the practice of law. He has not practiced law for 13 years. He was eligible to apply for reinstatement in 2005, and we are now 5 years beyond that. He has become learned in the law and competent in the law by his activities, but given the unique situation that faced him of overbearing family influence on the way he practiced, the hearing panel and then the board thought these conditions would assist him in his transition back to
Mr. Carney,
practicing law.
was he representing his brother?
No, Your Honor. The two of them would usually go to court. It most often would be a small claims action. It would be titled James N. Ellis Jr. and Nicholas Ellis versus whoever the person was that they were seeking reimbursement. They might be seeking $400 that was paid for a medical examination. They might be seeking filing fees that they had advanced on behalf of the client. The usual practice was both lawyers would be in the courtroom, but only one would get up and address the court, because if the court were persuaded by that individual, the identical ruling would apply to the second plaintiff. So there was no need for them to double team, especially in a small claims action.
Was he keeping bar counsel informed of the cases he was working on?
No, Your Honor. Although bar counsel was aware of what he was doing, because at one point she contacted Attorney Angelini and said that there may be confusion because the father practiced on the second floor of an office building, the son practiced in the basement, and bar counsel said people might be confused. So Mr. Ellis vacated that and began working out of his home. He also changed the phone number so that it would be totally independent from that entire building. When he was told by Mr. Angelini that bar counsel says the pleading titles have to be different, or the parties have to be listed differently, he changed it. And the hearing panel specifically notes on page 8 of its report that after this advice was given to bar counsel to Attorney Angelini, and he told it to the petitioner, quote, the petitioner understood this advice, and we credit his testimony that he tried to follow it. So every change suggested by bar counsel and initiated by bar counsel was adopted by the petitioner so that he would never run afoul of this court.
Mr. Carney, you may not know this, and I don't know if it's in the record. Is there anything in the record about whether or not the brothers assigned claims to each other, assigned their own rights and claims to each other?
Occasionally this was done, and I believe there is evidence in the record. The Demers case is an instance where the petitioner assigned his interest in the case to his brother, James, and his brother was the only one who appeared in court. So certainly in that instance, it was assigned. Bar counsel contends that my client has not shown his moral qualifications. I respectfully disagree. This court, through your rules and case law, have instructed lawyers who have been disciplined, including lawyers who are disbarred, on what they have to do to show this court, for example, that they have the moral qualifications. The hearing panel made very specific findings in this area. They talked about how the petitioner acknowledged his misconduct. He repeatedly indicated he was responsible for the misconduct. He did it. He's the one. And he did not put responsibility on his father or on his brother for the 2 misdemeanors to which he pleaded guilty. Indeed, when he was pushed a little on it, his response was, I lied. It was my responsibility. I take responsibility. I'm the one who committed those crimes. The last of the 2 misdemeanors being in 1992, 18 years ago.
Mr. Carney, let me ask you this. I'm going back to the 1997 original disbarment. One of the things that concerned the court then was the collusive wrongdoing between the client and the lawyer. There was a whole... I'm not sure why the hearing committee and then the board ultimately put the restrictions on what they placed the restrictions. I suppose perhaps thinking that workers' compensation and personal injury cases are more capable of collusion between a client and a lawyer. That seems pretty harsh for people who have legitimate workers' comp claims. I mean, what is it? It's a different way of asking the question, I think Justice Cordy or Justice Gantz asked, which is, why those areas? I mean, what's the board trying to get at?
I think it's trying to get at, Your Honor, the third condition that a lawyer has to meet, which is to show that the effect of reinstatement will not be detrimental on the bar, on the administration
No,
of
I
justice.
understand that, but I mean,
Well,
why these cases? I mean, there can be all kinds of accident cases, you know, insurance fraud is very typical. I can't even remember what the form of fraud was. Was it insurance fraud in the end of,
Motor vehicle.
was it motor vehicle fraud?
Yes, Your
But
Honor.
he's not barred from that, and he certainly knows how to do that. He did it before.
I believe he is barred from it.
Is he? I'm
That's
sorry.
you'd say that's part of personal injury?
Yes, Your Honor.
That's personal injury, okay.
Well, I of course can't speak for the hearing panel
Sure.
or the board, but I can offer one reason why this was done.
Okay.
Ellis and Ellis was demonized in the county of Worcester. This was an extraordinarily high-profile case, numerous press conferences by the Attorney General. This was going to be the end of this law firm. The amount of publicity at the time that this case was pending was enormous. People with long memories in the legal community in Worcester know the Ellis and Ellis case because it was so central in Worcester. In order to help assure the public that Nicholas Ellis is not simply going back to practice in the same manner that he did, with the same people that he did, and thereby resurrect this demon law firm, Ellis and Ellis, I believe that the hearing panel and the board wanted to make it clear to people that he would not be going back to work with his father. He would not be going back to personal injury and workers' compensation, so that people will not be able to say he is simply being reinstated as a lawyer so that he can go back to what he did before. I submit that these restrictions on his practice that he has not objected to in the slightest will give people confidence that although he is reinstated as a lawyer, he will not be going back to work for his father, and he will not be going back to personal injury and workers' compensation. And that will provide added confidence to people in the community that this is not simply an effort to resurrect Ellis and Ellis.
Does the
Because
record,
it's not.
does the record show where he does intend to practice law?
With a degree of specificity of identifying individuals. He will work in a group setting with other lawyers, each of whom has independent practices. The record reflects he has spoken to each of the lawyers in this group setting. Each of them has welcomed him if he is reinstated and stated that they're happy to have him as a colleague. Although the...
In Worcester?
Yes, Your Honor. And he named the individuals in his testimony. All the bar associations, the major bar associations, get notified if they want to have an objection to this because it may impact adversely on the standing of the bar or the view of the bar, and no one has objected as a bar association. Individual lawyers were given an opportunity, I submit, because there was a big article on the fact that Nicholas Ellis was seeking reinstatement, and not a single lawyer came forward and said it would be detrimental in their opinion to the bar. And I think when one looks at the entire case here, Nicholas Ellis has shown that he does warrant reinstatement because he has followed exactly what this court has asked him and others to do.
Thank you, Mr. Carney.
Thank you, Your Honor.